Okay, on the next elements of the offer. So for the sixth one, you have the freedom. Okay, this is the freedom. What's the called freedom is? So the freedom is parties should have to enter any contracts freely without any pressure. So of course, when you want to do the to sign an agreement, right, you cannot be forced. Of course, that's very clear. Okay, in section 10 states that every agreement is a contract if it is made by free consent of the parties. Okay, on that basis, every contract must be voluntarily done without any negative element which affects the person's capacity to make independent decisions. So you have to do your own research on that, and you are going to sign for that. It's just like you are going to put your money somewhere, so it should be freely without any any force from someone else. Okay, independent decisions are decisions which are made after due considerations of the effects of a contract on the person. Okay, independent decisions are decisions which are made after due considerations of the effects of the contract of the person. Okay, next one is the party should enter any contract. Again, this is symptoms. Okay, so you can see that in these sections, right, any parties who enter any contract consider freely if they enter without this one. First one is force. This is coercion, means that you're forcing, is not force. Okay, without undue influence, nobody influence you. The third one is fraud, cheating, and the last one is misinterpretation. So this is four of them. Okay, this is the one that make sure that you are entered the contract correctly. Okay, the next one is the certainty of the contract. So if you have a contract, you must have a certain timeline. It means that there must be a date here and there. Cannot be a vague contract, so it must be certain. Okay, let's look at the elements for this one. Okay, any contract should be legal. Okay, the terms of contract must be certain and not vague. It must be clear. An agreement which is not certain or capable of being made are void. Okay, which is if you don't have this particular things that inside the contract, of course it's void. So agreement, the meaning of which is not certain or capable of made certain, are void. Okay, certainty, this is very clear. You must know that there will be a certainty on the contract itself. So every term of the agreement must be certain or capable of being certain. That's why in your contract agreement is very thick normally. So they tell you which term is which term normally for you to follow and to understand the terms, because it must make certain on that. Okay, so the case, for example, is Karapian Chetty versus Swan Tian. So this is written agreement. All right. The fact of the case is the parties agreed upon granting of a lease of RM35 ringgit per month as long as he likes. So this is quite vague. Okay, this is a case of 1916. So issue whether the use of for as long as he likes had realized the ambiguity in its terms. So of course you don't have a certain period for this one, right? So the court held that the requirement of certainty had not been satisfied, as the durations of one of the most important terms of the lease was undefined or uncertain. Therefore, the agreement is void. So reason of decisions. The language used by the party is not specifying, too vague. In a nutshell, all uncertain contracts are void by virtue section 30 and Contract Act 1950. So it must be clear. Okay. So for the terms and conditions, right, here is a very essential requirement for a contract to be legally binding. Okay, that the parties have reached the agreement. So this term of agreement which they have set out, writing and partly verbally. These terms of the agreement which they have set out in writing verbally, or a mixture of the two, are known as express terms. So this is the terms and conditions. These terms has been divided into two types. Express terms, terms that are expressed and agreed by the parties orally in writing or partially in writing. So the implied terms are terms that work on the presumed intention of the parties to give effect to the business efficiencies of the contract. Okay, The express and impact terms are divided to conditions and warranties. Okay, the conditions are stipulations essential to the main purpose of the contract. If there are any breach of the condition, the injured party may only claim for damages. So the terms and conditions normally inside the contract. This is terma perjanjian. Then you know that the lawyer thinks all the thing. We write down what is the term and condition for you to accept the agreement. Okay, so there are two types of them. They call it express terms and impact terms. Discharge of contract is a process where you want to don't want to get binded anymore with the contract. Just for example, that the terms is used when you want to when you get up from the hospital, right? So you're going to be discharged from the hospital. So you're not connected to the hospital anymore. So for the terms here is the discharge of the contract, right? So it's the same thing that you're going to remove yourself from the contract itself, right? So it's an example way for the parties to separate it from the agreement. So that is the meanings of the discharge of the contract, right? So there are four ways of to discharge from the contract. The first one, they call it performance. Second one is breach. Third one is by agreement, and the last one is by frustration. So to make it very brief, it's very simple. When you're going to discharge with the contract, is the first one by performance. Performance means you complete the contract itself. The second one is not by completing the contract. The third one is by agreement, and the last one is by frustration, means that it cannot move on to complete the contract anymore. So we're going to look at that particular example one by one. So for the full performance, so before I go for this case, right? So let's look at a very simple contract. If you are a student, right? You get a loan or scholar for the overseas study, right? Then after 3 years, you get your degree or your master degree, and then you complete means you perform the contract. So after you complete your master's degree, right? So then your contract is completed. It's very simple. This is by performance. So let's look at the example here by performance. It's actually a contract may be discharged by full performance. A case of Carter versus Powell. Okay, this is related to the contract itself, based on performance. The fact is the defendant contracted with a seller promising to pay him. So this guy is asking this seller to provide as a services as a second mate aboard a ship until it reached Liverpool. This was a substantially more money than normal sailor contract, which tended to pay a smaller sum per week of service. So it's kind of different rates. The sailor did his job, okay, but you see this one, but eventually he died before the ship reached to Liverpool. So the contract say until it reached Liverpool. The sailor extended suit for his wages under the contract. This is the relative try to fight for the wages or the payment for this guy, or in the alternative under the quantum merit rule in restitution. Okay. So the question is, was the sailor owed his wages under the contract? So is it there's a wages for the sailor based on the contract? Okay, could the sailor quantum merit for the performance? So the decision is held in favor of the defendant. So the sailor cannot get the whole wages because of the contract say ship to Liverpool until Liverpool. See, the court held favor of the defendant. The contract promised 30 guineas. This is money here. This is like RM. Only if the sailor worked the entire voyage, which he did not because he died. The obligations to pay therefore never become life. Okay, the contract offered more money if the whole job was completed on the assumptions that the sailor would be entitled to nothing. If it was not, he settled could not therefore only on quantum merit. So the conclusion is the sailor did not perform on the contract. So the performance is not good. Okay, the next one is breach. So what is breach? We had been maybe you guys are very familiar with the terms of breach of contracts, all the stuff. So that is related to performance, whether you are perform based on the contract or not. So breach is one item that can discharge you from the contract. So it's a base performance, which means that there's no performance by the contract here. Time and place in conditions. Okay, that's the first one. Or the second one, a party expressed its intention not to perform. So it means that you can tell the one that you made the contract that you're not going to perform it anymore. So you have the intention to breach the contract. Okay. So another one is a party acts in such a way as to show its intention not to perform. So you can conclude that all this one is based on the non-performance of the contract. Example here, for example, you are given a scholarship to go to overseas to complete your master degree in 3 years. So it's between in these three years, right? You can express your intention. If you have problems, you want to proceed with that, you still have intention to do the to not continue, means you're breaching. Or maybe after 3 years you still coming back with your master degree is not there, you are not getting any degrees, so you already actually not performing under the contract, also you are breaching the contract. So this is another method that how you can be discharged from the contract itself, right? So that's very simple for the breach. And the third one, they call it a frustration. So just now we have the first one is performance, the second one is breach of the contract, and we're going to do the fourth one first, the frustration. Because the agreement is quite simple. Agreement is you just agreed with each other to discharge of the contract. Okay, but for the frustration is a bit different. Okay, frustration is a contract that subsequent to its formation and without fault of either party, there's no problem with other party, is incapable, okay, is incapable here of being performed due to unforeseen events, okay, resulting in the obligations under the contract being radically different from those contemplated by the parties to the contract. So you have a contract, and somewhere between the contract there's a problem that caused that contract cannot be performed anymore, that the contract cannot be fulfilled anymore. So because of the issues, I mean, there's a thing that going to have a problems on the object of the contract. So there will be no output from the contract, so there is a problem. Okay, that's why they call it frustration. Frustrated contract means that according to this one, the contract also you can be discharged also from the contract. Okay, so from the section in the Act, it will say that any agreement impossible to proceed is void. So this is the one, impossible to proceed is void. Okay, so this is just the same thing again. The lines over there. So we just want to look at possible of the example here. Let's look at the case from the frustration concept. Let's look at the first case, Taylor versus Cardwell. This is related to the music hall in Surrey, where the claimant hired out a music hall in Surrey for the purpose of holding 4 grand concerts. The claimant went to great expense, meaning that he already spent so much money and effort in organizing the concerts. However, a week before the first concert was due to take place, the music hall was destroyed by an accidental fire. Okay, the claimant sought to bring an action for breach of the contract because he think that the person who give for him to hire the hall is not following the contract, so he wants to say, because once you want to go for the breach, you want to get some compensation anyway for the breach. But here the claimant sought to bring an action for breach of contract, the second one just now, for failing to provide the hall and claiming damages for the expenses incurred. So he wants to ask for his money. Alright, so what's the results here? So the claimant's action for breach of contract failed. So the case here, the discharge is not based on the breach, because the issue right now is this tailor is not breaching his contract. The problem is this accident, right? The contract had been frustrated. That's why they call it frustrated, as the fireman, the contract was impossible to perform. So because of the fire, you don't have any more the hall, so how to perform it, right? So it's quite clear that this is not going to be happen based on this one. Any agreement impossible to proceed is void, right? So the hall is destroyed by fire, then the contract is discharged. So that is the fourth one. Because the fourth one here, yeah, performance breach. Agreement is very simple. Both of you agree to discharge, then you discharge. And the last one is frustration. In the second cases is regarding on the Krill versus Henry. This is related to the King George coronation day. So what happened was Mr. Henry, the defendant, established a written agreement with Mr. Krill to hire his flat in Pall Mall. So Henry wants to hire a flat to cover. Right. So he could watch the coronation processing taking place in that way. The defendant paid deposit and the contract was established. The contract did not contain any express. So here, the contract did not contain any express or implied reference to the purpose of the hire. It does not state anything. But what happened later is going to be shown in the court, where this is the foundations of the renting purposes. Okay, when the king got ill and consequently the event was postponed, the defendant refused to pay the agreed amount of rent. So he has another £50 to pay, because the first one is 75, deposit only 20. Deposit only 25, and the rest it should be coming after the complete of the renting contract. So what happened since the contract did not include any reference to the coronation procession, could the postponement frustrate the contract? So the king was sick, and the coronation is not performed. So is it going to be frustrate or breach the contract? So in this case, right, what happened was the Court of Appeal dismissed the appeal by the plaintiff. So Cravel lost in this event. Okay, in the court, the court held that from the circumstance that both contracting parties were aware of, the coronation procession on the origin fixed date was the foundation of the contract. So Henry Henry wants to rent the flat because of the coronation day, but it was not stated in the agreement or in the contract. Eventually, this is the real reason why Henry wants to rent the flat, and it implies in this contract. So because of the King George was sick, so the coronation day cannot be proceed. So that's the case. Both parties regarded it so. Okay, this is because of the date. It actually implies, means even though it's not stated in the contract. Consequently, in Krill versus Henry, Mr. Krill could not recover the fixed amount of the rent from the defendant because it was frustrated. King George was sick, and the coronation day was not performed. So that's another types of example of frustrations of the contract. It's not breach, it's frustration because it cannot occur. Okay. For the rest of the case, you may just Google it to get the understanding on that. And then, so once you have the breach contract, right, then you will have the remedies. So remedies is why. So if there is a breach of contract, okay, other parties who suffer damage from the contract can take actions to recover his loss. So that is very important of the contract, because if anything happen, if the person who received the contract breach it, not frustrated, right? Breach it means that you can get some remedies. Okay, so breach of contract means any party who breach any terms in the agreement. Breach of the contract means this is the one just now. Okay, so remedies is coming from the breach. So there are two types of remedies. One, they call it damages, which is under that one we have the unliquidated damages, and the second one is liquidated damages. And the second remedies is they call it equity or equitable remedies, which is the first one is specific performance, and the second one is injunction. Alright, so let's look at the remedies, what we have for the damages. The first one, they call it unliquidated damages. What does it mean? So unliquidated damages is a legal remedy of monetary compensation. It's a kind of money which takes into account the measure of loss, the amount of which yet to be determined. So this is a keyword. Unliquidated damages is yet to be determined. Damages which arise that there are no subject to any contractual liquidated damages clause. So this is the terms. This is the keyword which is yet to be determined. Versus the liquidated damages, right, is a provision in the contract that fixes the sum of payable. So it means that if you are not performed in the contract, you breach the contract, you have to pay me 100,000. So that's a very clear. Okay, you have to fix the sum payable as damages for a party breach. No need to prove the actual loss, because that was under unliquidated damage if you have not measured yet. Okay, so this is clear in the contract. You put, you have to pay me how much, blah blah blah. So that's the case. So that is the unliquidated damages versus liquidated damages. So the second remedies, they call it under equities. So also two of them. One, they call it specific performance, and the second one, they call it injunction. So specific performance is actually a court order which requires the party in breach to complete perform their part of the bargain according to the contract. So it means that the court can ask the person who breached the contract to do certain things, to do some things that have to fix. I mean, to make sure that the someone who, that the person who had breached the contract can get something. Okay, so this can include requiring the breaching party to deliver. So anything, this is a specific performance. Right, this is the case. Maybe he wants him to pay this one. Maybe he has to pay to give back his land, something like that. So the next one, they call it injunction. This is all the law terms. Injunction is a court order that demands a party to stop doing a specific act. So let's say, for example, the especially very clear about the suing things, about talking something bad to the people, and people sue it, and then he win the case, and then he got the injunction from the court for the person not to tell or make any announcement or any news about the person. That's a court injunction, which is a court order that demands a party to stop doing a specific act. Is causing irreparable injury to the plaintiff which monetary damages cannot replace. So that is about the injunction. So there are two types of remedies for the breach of contract: was damages and equity. So you can know that there are two more items under those, damages and equity. Alright, that's for the breach. Thank you.